Are we live, guys?
Yes, sir.
Okay, let's go on the record on cause number DC 195912-9202 Saeed versus Abdel Hussein. Counsel, make your appearances.
Good morning. Farah Ahmed for plaintiff 9202 Saeed.
Your Honor, good morning. Jonathan Hernan, counsel for defendant Ready Real Estate LLC.
Good morning, Your Honor. Cal Hamida for defendant Abdul Hussein.
Let's proceed.
Okay. Your Honor, plaintiff has filed a motion to strike defendant Abdul Hussein's. It's his third amended answer, first amended counterclaim. In this pleading, they've added the pleading deadline in this case, Your Honor, was back in August. In September 15th, they filed this amended pleading, which asserts 13 new affirmative defenses, as well as a new counterclaim of declaratory judgment, which is essentially a creative repleting of their counterclaim, the breach of contract counterclaim, as well as several contract defenses that they asserted beforehand. And Your Honor, we moved to strike this amended pleading because it's beyond the deadlines. It is a surprise to us, and it's also prejudicial on its face.
So Ms. Ahmed, let me kind of ask you a question here, which is how many depositions have been taken in this case so far?
We've only taken one deposition, Your Honor, but it was a 2-day deposition.
Who was taken?
Mr. Abdul Hussein.
And that's the defendant?
That is the defendant. Now, Your Honor, I will say, though, there was one earlier deposition that we took, which was from a third part, which was of Mr. Hussein's agent. But that was, Your Honor, that was a mistake on our end because we thought all the parties were notified at that time. But opposing counsel and I, we filed a Rule 11. We decided we're not going to use that transcript. We provided all the documents. We provided all the deposition transcript of that deposition taken in error to Mr. Hussein. So, but that deposition is essentially, we decided that can't be used for evidence, whether for a motion or whether for a hearing. So, and we've agreed to retake his deposition if needed be.
And then if I allowed them to do this amendment, would you need to retake Mr. Abdel Hussein's deposition?
We would have to do that, Your Honor, just because, and here's the thing, Your Honor, we filed their competing motion for summary judgments that has by Mr. Hussein and by us that we're waiting well, actually, Mr. Hussein's motion has already been denied, but we filed a no evidence motion for summary judgment.
I just ruled on that. Let me double check. Make sure you guys have seen it.
You did, Your Honor.
Your Honor, I apologize. It was, then I must have not seen the ruling yet.
Let me pull it up just so that maybe this will address some of this. Here we go. A lot of stuff filed in here. Let's see. Is it this one, 928? Is that the most recent? Okay, I think it's this one. Okay, can you, I'll share screen it. All right, have you seen this, Ms. Ahmed?
No, Your Honor, this is the first I'm seeing it. Okay, thank you, Your Honor.
So is it, I want to make sure I understand. So the petition that's been filed, is it add additional causes of action for this counter plaintiff, Abdel Hussein?
Yes, Your Honor. So it's essentially a repeat of his defenses and of his breach of contract. So, Your Honor, now it's, he's essentially is trying to relitigate the same issues again, where where he's trying to avoid the contract, which he formally tried to enforce against us. It presents no issues beyond what his defenses present to our breach of contract claim.
So what is so I've granted this to eliminate his causes of action that those were all of his causes of action. Is that right at the time?
Yes, Your Honor. It was all of his causes of action at the time. And now with his amended pleading, now he's asserting, now there's a new counterclaim, which, again, is indeed a surprise because this case has been on file since April of 2019. The first time he's asserted counterclaims against us was back in December. He hasn't presented any new evidence, Your Honor, in this amended pleading, which would merit bringing a new cause of action after the pleading deadline, after the discovery.
Ms. Ahmed, let me ask a question. So, and you filed a summary judgment on your affirmative claims, correct? Or no?
Sorry, Your Honor?
Did you file a summary judgment on your affirmative claims?
Not yet, Your Honor.
Okay, you said that I'd already ruled on another summary judgment. Was this what you were talking about or a different one?
The first summary judgment, Your Honor, was Mr. Hussein's traditional motion for summary judgment, which was denied.
Okay, and now this was on his claims, and I granted that one. Correct.
You denied his claims, his traditional motion.
I know, but you moved for summary judgment on his affirmative claims.
Yes, Your Honor. Sorry.
And I've granted that one, correct?
Yes, Your Honor.
Okay. And so I just want to make sure I'm kind of understanding all this. And so what they've done at this point is tried to add additional causes of action other than the ones that I've already dismissed, correct?
Yes, Your Honor.
Okay. All right. And all the scheduling, all the deadlines in the scheduling order have passed to allow them to amend the petition, correct?
Yes, Your Honor.
Okay. All right. Response?
Oh, absolutely, Your Honor. Let me fill in some blanks. Your Honor, this case was filed at the end of April 2019. And truly, we should be the plaintiff, but we didn't file because the contract had an ADR provision, which they disregarded totally. So we spent the spring and summer of 2019 trying to mediate with Ken Rubenstein at Burden Mediations. We eventually got in. Mediation was unsuccessful. Then we spent the latter part 2019 finding out that opposing counsel took the deposition of this real estate agent behind our backs. It took us 3 months, Your Honor, to negotiate a Rule 11 agreement for her not to use the transcript that she illegally took. After that, we finally got a Rule 11, 3 months negotiated. Ready Real Estate was brought into this lawsuit, Your Honor, at the end of the summer of 2020. They answered discovery on August 3rd of 2020. No other depositions have taken place. Basically, Your Honor, the uniform scheduling order had a cutoff date in August. We signed it on August 3rd. It had a cutoff date on August 11th.
So Ready Real Estate, do you represent Ready Real Estate?
No, they're the third party that's been brought into the lawsuit. That's okay. My client's real estate agent, who is now part of a lawsuit because of this 90-day clause that's so vague and ambiguous that no one can understand what it is. And we haven't brought any new pleading, Your Honor. We have sought a declaratory judgment with regards to this provision that says that my client has an option to cancel the contract within 90 days if the city of Dallas doesn't approve his rezoning request.
Mr. Hernan, do you represent Ready Real Estate?
Yes, Your Honor.
Okay.
Go ahead.
So I guess my issue is that there was a scheduling order issued and correct me if I'm wrong on this, if there's a scheduling order that was issued, it covered both 9202 Sain and Abdel Hussein, correct?
Yes, Your Honor.
And then later on, Ready Real Estate was added to this case, correct?
No, Your Honor.
They were also added simultaneously.
They had just been brought into the case.
Oh, they had just been brought in the case when the scheduling order, when it was signed?
Yes, Your Honor.
Oh, I thought you said they were brought in August of this year. It was August of last year?
No, August of this year is when the scheduling order, August 3rd is when Ready Real Estate had to answer discovery. But the scheduling order, Your Honor, was entered on July 13th of 2020.
So before Ready Real Estate was in the case, or
Yes, Your Honor. They had been in the case when the scheduling order was entered into.
okay. Okay.
Your Honor, they added Ready Realty into this case in December of 2019. Ready Realty made an appearance in mid-January of 2020. And the recent amending scheduling order, again, it was agreed upon by all three parties, and that was in July of 2020. And Ready Realty filed their petition, I believe, around July 31st, which is still about a month before the amended pleading deadline, before the discovery deadline. Again, they didn't present any new facts or any compelling reasons why they decided to file this last-minute amended, their new counterclaim past these deadlines.
There's nothing, if she's done, Your Honor, I've got just a quick reply with regards to the law.
Okay, go ahead.
Your Honor, as you know, under Rule 63 and 66, you have absolute discretion to allow my pleading. It's the opposing
I guess,
party.
and let me just say this, I understand that, I know the law on that. I guess and I will say that usually, though not always, I'll allow an amendment to a pleading past the deadline if I feel like it's not prejudicial or, but in this case, it feels like I've already ruled on this. We're just you're trying to get an end around on this ruling. I've already found that the ruled against your client on all of this stuff. You're just trying to add additional causes of action.
If I can be heard on that point, Your Honor.
Sure.
What you ruled, and again, I'll bring you back to the summary judgment, and I'm not saying I should deserve the same courtesy you give to opposing counsel, but if you'll recall, she missed her pleading deadline to respond to my summary judgment. She didn't file a response within 7 days, and I should have been granted summary judgment, but the court allowed her on the motion for leave to file her response, and my summary judgment was denied. But with regards to the summary judgment that you granted, Your Honor, it was on a breach of contract. It was on a breach of contract claim. I'm not bringing a breach of contract claim. I'm bringing a deck action for the court to rule on this 90-day provision within the contract. I'm not suing them for breach of contract. So for her to say,
I've read this provision. I don't know why you think it's unclear. I don't think it's unclear at all. I mean, I will say this, that this isn't a ruling, but it is a cautionary statement, which is if I allow you to assert this deck action and I rule against you, which I think I will in all likelihood, then your client could be subject to attorney's fees under the Declaratory Judgment Act. Is that really what you want?
well, I believe that is fair, but that's not what I want. But in a prior hearing, Your Honor, you did mention that you personally believe that provision to be vague, and I think you even in dicta had maybe said that it may not be enforceable. So, I mean, if the court's changed its mind on that, I'd still like to take my chances at trial, present you all of the evidence, present all the testimony, and have the court rule on that provision, because that provision, I've looked at it. And I've got real estate lawyers look at it. No one can make heads or tails out of it. So I understand that if you rule against my client, we would have the privilege of paying attorney's fees. And I would like to take that chance, Your Honor.
Mr. Hernan?
Just briefly, Your Honor, I mean, for the same reasons that Ms. Ahmed spoke, is we oppose co-defendant's motion for leave. And we also had a question about the trial date. The parties unfortunately weren't even able to agree to extend pre-trial motions, despite the fact that trial is going to automatically be reset. So that's something that we also wanted to discuss if possible.
When is your case set for trial currently?
Next Tuesday.
October 20th,
Is it a jury or non-jury?
jury.
It's jury.
Yeah, we would need to reset all of this. All right. I'm going to grant the motion to strike. So if you can, did you already submit an order on that, Ms. Ahmed?
I believe so, Your Honor. If not, we'll submit one today.
Okay. So and I'm perfectly okay about talking about the trial setting. So as you know, we're not going to have any jury settings this next month or next week. The newest thing that we have, there's about to be a order, I believe, that's going to go into effect about jury trials in Dallas County. What essentially it's going to say, without going into a lot of detail, is the jury selection is going to be remote. Trials will probably be live. But that being said, there's no juries summoned for next week, so we couldn't do a jury trial. I'm open to suggestions on when you want to reset it to. We are starting jury trials, I believe, in November, but it's going to be just car wrecks for that first summons. So I don't think setting November makes a lot of sense because this isn't a car wreck. December is pretty unlikely. So the earliest I would really recommend resetting it to would be January. That's kind of up to y'all what you want to do.
I was going to say, Your Honor, anytime in the winter or spring 2021, January for us works perfect. So however council wants to proceed.
Ms. Ahmed?
Your Honor, we have no preference right now at this moment. Whatever is best for the court or whatever is best for everyone else.
Mr. Hamida?
January is fine, Your Honor.
The only date in January that we possibly could do this would be the week of January 5th, if that makes a difference. Or we can move it to February if you prefer.
It might be better to not have it the week after or the first week of the year.
Yeah.
February might be better, Your Honor.
February might be better.
So let's do. What week in February do you want?
Our calendar's open, Your Honor.
Likewise, Your Honor, so far it's open.
So let's see, Rhonda, when do we have special settings in February? Rhonda? Why don't we set it for, let's see, okay, we could do the 2nd, the 9th, or the 23rd.
The 9th or the 23rd would be fine.
9th or 23rd, Your Honor.
It's up to you, Mr. Amado, which would you prefer?
I'm looking.
Have y'all been to mediation on this yet? You said you did, right?
We went just with the plaintiff.
It was in June of 2019.
I'm sorry. We have not been with Ready Real Estate. We had set one back up with Ken Rubenstein to go back with Ready Real Estate, but as usual, at the last minute, Farah and her firm canceled the mediation.
We never agreed to going to the second one, so.
It was your suggestion to go back to mediation.
Yes, but we didn't schedule it with Burn mediation. Burn assumed that all three were on board.
Okay.
So, Judge, are you ruling that they were surprised by my pleading? Is that why you're granting her motion to strike?
Yes.
Okay.
All right, February 9th or 23rd.
9th would be fine, Your Honor.
Thank you, Your Honor.
All right, let's go ahead and, Rhonda, go ahead and reset this case for trial on February 9th. Anything else, guys?
No, Your Honor. Thank you.
Nothing further, Your Honor.
Thank you, guys. You have a good day.
You too. Bye-bye.
Bye-bye. And get us the order in.
Yes, sir.
Okay, I guess we don't have anyone here for the 11 o'clock. I guess that may be canceled. Okay, well, how did you guys enjoy? Tony, our next one is at 1:30. Rhonda, our next one's at 1:30. So we'll see you guys at 1:30, okay?